today we're going to be talking about, thank you everyone for participating. Today we're going to be talking about effective board meetings. And I can tell you this is one of those topics that sounds simple on the surface, right? But in reality, it's where some of the biggest challenges in the communities actually show up, whether it's meetings running too long, going off track, or just not getting clear decisions made. We see this come up all the time. So today is going to be very practical. You're going to walk away with a better understanding of the legal side, a clear structure of how you can follow a structured board meeting, and some best practices you can apply right away. Our goal fundamentally is to keep this simple, actionable, and useful, okay? And this is also meant to be interactive. So as Ken, director, who I'll be introducing in just a moment, is sharing information, knowledge on different topics regarding effective board meetings, I'm gonna ask you to, in the chat, go ahead and ask those questions, and I will pick and choose those to bring to his attention to have further discussion and dialogue on. All right. And then, so we're most likely not going to have a Q&A due to time restraints. So I am going to encourage you to provide those questions as Ken is sharing that information. Okay. All right. So let's go ahead and get started. It's 12:04. Let me introduce myself. Hi, everyone. I'm Michael Manrique. I'm the Director of Business and Development for Affinity Management Services. We work with community associations across Florida, supporting boards and communities with day-to-day operations, financial management, and overall governance. And one of the things we see consistently, regardless of the size of the community, is that the effectiveness of board meetings has a direct impact on how well the entire association operates. Okay. So that's what we're going to be focusing on today. Before we jump into the content and I introduce Ken, I want to quickly cover how you'll be receiving your credit for today's course, since this is a Florida State accredited class. So to ensure you receive your CU credit from the DPR, there are just a few things I want to highlight. So first, you'll need to remain present for the full duration of the session. Second, please make sure your name is clearly identified in the webinar platform attendance so it can be verified. We'll be providing a course evaluation at the end. So make sure to stay to the end. When I share that link, you would just complete that form. And then that would be the way that we know for certain that you met this criteria. And then if applicable, we'll provide additional instructions, okay? What's really important is we'll be keeping this simple and guide you throughout it. So you no need to worry, just stay engaged and you'll be all set, okay? All right, let's get started. So I'm really pleased to introduce today's speaker, Ken Director. I know Donna was supposed to be here originally, but we do have the absolute privilege to have Ken with us today. Ken is the chair of Becker and Polyakoff Condo, Co-op, and HOA Practice Group, leading a team of over 50 attorneys focused on community association law across Florida. He personally represents communities from Miami to Vero Beach and brings extensive experience in governance, financial oversight, insurance, and operational issues affecting associations. He is board certified by the Florida Bar in Condominium and Plan Development Law, which is an elite distinction held by only about 5% of attorneys and considered the highest level of expertise in this area. In addition to his legal practice, Ken is a recognized educator and speaker, having presented for CAI, the Florida Bar, and multiple industry programs, and has even taught community association law at Nova Southeastern University. Ken, I'll turn it over to you. Thank you.
Thank you for that introduction, Michael. My mother would be proud. And for those of you expecting to see Donna, I'm sorry to disappoint you, but she is under the weather and has asked me to step in for her. So we're talking about board meetings, and I think the appropriate place to start is, what is a board meeting? A board meeting is any time a quorum of the board is together discussing association business. And I'd ask you to process that because it's a very broad concept, and it's intentionally broad because the legislature wanted to make sure that the board operated in a transparent, open manner and did so in front of the community. So the fact that 4 of 7 board members are sitting having a drink is not a problem, but if they're discussing association business, it is. And as Michael correctly pointed out, the manner in which the board conducts its business has a direct, visceral, significant impact on the atmosphere in the community. So a business-like board meeting that is held in accordance with all the legal requirements is of vital importance. Otherwise, you are simply going to fuel resentment and mistrust, which simply benefits only one sector of our society, and that's lawyers. So a board meeting is any time a quorum of the board is together discussing association business. Do not assume that the board can make decisions by circulating emails and taking a poll. Board decisions are made at board meetings, no other place. So some of you may be thinking, and I'm going to give you a real world example. It's December, holiday season, and the pool heater quits working. And you have people in town, people coming to town, and the pool water is going to get too cold for people to enjoy their morning swim. And you don't have another board meeting scheduled until the month of January, sometime middle or latter part of that month. And you have a pool heater guy, the guy who serviced your pool and installed the prior pool heaters is accessible to you. What do you do? And you can't reach other board members because they're out of town for the holidays. The law does allow for what I would call common sense, but I would encourage you not to let the exception become the rule. I have advised clients in those exact circumstances, have the president reach out to the other board members, say, we don't have a board meeting scheduled. I'm going to bring out Michael, who's done our pool heaters for years and serviced our pools. I'm going to have him replace the pool heater. It's $12,000 or $14,000, whatever it is, but we need to have it. We're going to replace it anyway. And if we don't do it now, the residents are going to be up in arms because they can't swim because the water's too cold. Unless a group of the board members responds and says, this is, can't do it, don't do it, I object, I'm going to file lawsuits, etc. You do it, you put it on the agenda for the next board meeting, and you ratify the decision. Again, that is a way to entertain emergency matters that come up and do so in a way that is legal and proper. Again, the exception should not swallow the rule. Who can call a board meeting? Well, this is a question that is answered in part by your bylaws and in part by the statute. Most bylaws provide for regular board meetings, or at least an annual board meeting, but they also all provide for what are called special board meetings, which is anything else. A special board meeting typically under the bylaws can be called by the president or a certain percentage of the board members. Sometimes the vice president can also call board meetings. But the statute also provides that if you receive a petition signed by 20% of the owners, you have to call a board meeting for whatever items they want to discuss within 60 days of receipt of that petition. Now, I hasten to add, you're not required to act on what the members have petitioned the board to discuss. You're not required to decide the way they want you to decide. You simply have to put it on an agenda and call a board meeting to address their issue. So we understand what a board meeting is. We understand who can call a board meeting. How do you call a board meeting? And the notice of the board meeting is of critical importance. There are notices to go in 2 directions. There is notice to the members of the board, and some older bylaws require more stringent notice than what the statute requires for the notice to the membership. Sometimes the bylaws will require 3, 4, 5, 7 days notice to the board members of the board meeting and require it to be sent by regular mail or by email. Older bylaws probably don't contemplate email because there wasn't such a thing when the bylaws were written in 1972. But you need to comply with the notice requirements or the meeting will not be valid and the actions taken will be subject to challenge. You should also make sure that you have adopted a rule that addresses where notices to the members will be posted. If you don't have any condo property, which would be very, very unlikely, you can post on association property. You can also adopt a rule to engage in broadcast notice in lieu of actual posting. I recommend posting. Not everybody is going to be checking their email or watching the association closed circuit channel. If you have a clubhouse or other office or your elevators, it is always best to post notice. You do not want to undermine the credibility of the board or the actions taken by not properly posting notice of all meetings. Again, adopt a rule to specify where you're going to post notice. And for those of you who live, and in 1 second, I'll come back to you, Michael. For those of you who live in HOAs, the notice can be mailed or delivered if you're not going to post. Michael, you had a question.
Yeah. So what in your experience today, what's the most common compliance mistake you see boards making when it comes to providing notice?
Well, actually, most boards are pretty good at posting notice in a timely manner, but there is often an an incentive or a desire to treat everything as an emergency and say, can we just convene an emergency board meeting to hire a new landscaper? Can we convene an emergency meeting to hire a new management company? Um, your failure to plan is not an emergency. And if you begin to do everything on an emergency basis, you do exactly what Michael cautioned you not to do at the beginning of this webinar, which is the board looks like they don't know what they're doing. You have to have a business-like meeting, and I'm going to talk about other things that help you have a business-like meeting, but giving proper notice is the starting point. Go ahead.
So we just got a comment that they asked if you could define what stipulates status. Statute reads, notice must be posted conspicuously.
Yes.
If you could define that for them.
Someplace where people will see it. I mean, conspicuous is exactly what you think it means.
Right.
And frankly, the way that you avoid any conflict over that is you do what I recommended a moment ago, which is the board adopts a rule to identify the location where notice will be posted, and you publish that as part of your rules, so people know where to look for notices. If board meetings are conducted with a video component, the notice must include the hyperlink. The meeting must be recorded, and for communities of over 25 units, the recording must be posted on the website for at least a year. So the next question is, where can the board meeting be held? Because we have people who are local, we have people who are not local. The board meeting can be held virtually anywhere, but you have to offer a site at the property for the people who want to attend in person at the property. I have very few communities that hold board meetings that aren't held on site. And Michael, I assume the same goes for you with your experience as well.
Yep.
I want to talk a little further about the notice, though. It is essential to have an agenda. This benefits the owners because they will come knowing what's going to be discussed. This will benefit the board members because they can come prepared, hopefully prepared, to discuss the items on the agenda. Having an agenda allows the board to, for lack of a better word, control the meeting. It allows you to say, these are the items we are here to discuss and act on. It prevents an individual board member or a group of owners from hijacking the meeting and forcing you to address items that are not on the agenda. I cannot overstate the importance of having an agenda and having the agenda drafted in such a way that it covers the things you want to vote on. The attention that is required when you create an agenda as part of the notice, the importance of that level of attention cannot be overstated. You cannot take things up that are not on the agenda unless they are an emergency. And again, emergencies, let's face it, are rare. Absent life safety risk or some other significant risk to the community, the agenda should be clear and it should be specific enough to cover the points you want to cover, but also general enough to include the things you want to include. And I will give you a real world example. For meetings at which special assessments are going to be considered. And by the way, in terms of notice, 48 hours notice is the typical requirement for condos, co-ops, and HOAs, at least in terms of notice to the owners. The agenda requirement is across the board, but for condos and co-ops, meetings at which you're going to levy an assessment, adopt a budget, impose rules that affect the use of the units, or set your insurance deductibles, those meetings must be noticed, posted, and mailed to all owners at least 14 days in advance. And for special assessments, the notice must specify that a special assessment is going to be considered, specify what it's going to be used for, and specify the estimated amount. Now, I emphasize estimated amount because you can impose the assessment for a different amount than is in the notice if the estimate proves to be inaccurate. Hopefully not wildly inaccurate, but inaccurate. But in terms of the purposes for which the money can be used, you're going to be held to what is in the notice of the meeting. So I'll give you an example. If you're going to undertake a significant construction project like a concrete repair project, when you say the purposes of the assessment are for the concrete repair, you've been incomplete. Because if you're financing that project, the assessment can also be used to collateralize or repay the loan. The assessment can also be used or should also be used to cover permits and professional fees like lawyers' fees and engineering fees. These things all need to be addressed as part of the agenda when you identify what the assessment will be used for. So be very careful with that part of the process. In order to have a valid board meeting, you must have a quorum of the board present in person or on a video conference. Board members attending by video conference or even by audio conference are considered present for the purpose of constituting a quorum. What if someone shows up at a meeting and doesn't want to vote on an item? And this actually comes from a legislator who was caught off guard at his own board meeting on a redecorating project that he was not prepared to discuss, and he was told he could not abstain because he did not have a conflict of interest that he could assert. So he got the statute changed to say you can abstain. I don't recommend that. It doesn't reflect well if board members are abstaining. It basically is an admission that you're not prepared to engage. You either vote for or you vote against. If there's a conflict of interest that affects one of the board members and you're considering a contract that implicates that conflict of interest, this needs to be brought to the attention of the owners, and the proposed contract has to be attached to the notice. It is also important in noticing board meetings, not just this instance where a contract is going to be considered, because the statute now requires contracts to be posted with the notice, although that law has not yet been addressed or analyzed by a court or even by the DBPR. Some people think that the copy of the contract is only required for board meetings at which 14 days notice is required. Other people think that the contract has to be posted with the notice. Now, if you have a 95-page AIA contract for your concrete restoration, you either need to have a very big bulletin board or you need some other approach. I have advised clients that have a website that you post the notice and the contract on the website, and in the notice you specify that the contract is available on the website where the notice is posted. To me, that is a more logical, practical approach. What happens if a board member shows up at a board meeting, participates in the discussion, votes on the items, and then later challenges the notice of the meeting? You can't show up and participate and then later challenge the notice. If you show up at the meeting solely for the purpose of challenging the sufficiency of notice and don't participate, your challenge has to be addressed. But if you show up and participate, you waive your objection to notice. I also want to point out that for condos that are residential with more than 10 units, the board is required to meet at least 4 times per year. Let me pause for a second. Michael, are there any questions coming in, or can I continue?
Yeah, so let's see here. From Alice, just attended a Zoom only board of director quarterly meeting, no on-site location or off-site made available, legal meeting or any business enacted not valid.
It is my position that a board meeting cannot be only by Zoom, because then you are effectively precluding people who don't have a computer or don't have an internet connection. There must be a site where people can attend. I do not believe that Zoom only is permitted. I don't believe it complies. Let's talk for a moment about board meetings that are exempt from the requirement that they be open to the members. There are two types of board meetings that are subject to being closed to the members. Number one, a meeting with counsel to get advice about pending or threatened litigation. Now, I'm sure everyone can understand that, because if you're going to get legal advice about the relative strengths and weaknesses of the association's position in potential litigation, that should not be public. Because if it's public, guess who gets to hear it? The people who you're suing or who are suing you. And they're not entitled to be privy to your strategy discussions with your counsel. Do not assume, however, that anytime you meet with your counsel, you can close that meeting. That exception is for proposed or threatened or pending litigation. It's not for anything you want to talk to your counsel about. The other exception is for personnel. And this is an interesting issue because personnel is a specific topic. Personnel means your direct employees. Personnel does not mean a meeting to discuss your management company. Personnel means you have direct employees of the association for whom you want to do year-end evaluations or discuss problems or discuss termination or even discuss hiring. But this does not apply to outside vendors like your landscape company, your pool company, or your management company. Those meetings are still required to be noticed and open to the members. So I've covered a lot of preliminaries. Now let's talk about the actual meeting itself. How do you conduct the meeting? You open the meeting by your chairperson. A chairperson should be selected in advance. The chairperson will call upon the secretary to verify that notice was properly given, or the manager to provide that verification. For notices that have to be mailed at least 14 days ahead of time, there should be an affidavit of mailing for your records. Bear in mind that the Postal Service recently modified their rules, because we're learning now that items that you take to the post office may not be mailed for a couple days. So I have modified my affidavit of mailing to say the notice was timely deposited in the mail instead of saying it was mailed. Now, at some point, the division or the legislature may require that when you're going to mail, other than email, when you're going to mail, you have to allow 3, 4, 5 days ahead of time in addition to the minimum mailing period. That's not uncommon in the way the courts look at mailing notices. While I mentioned email, notices can be emailed to only those owners who have consented in writing to receive notice by email. You cannot email to people who haven't consented in writing to get it. Now, we live in the year 2026. I'd ask each of you to consider how many of your owners don't have email. I imagine that's a very, very, very small number. So if you haven't begun collecting consents to receive notice by email from your owners, you need to make a full court press to do so. First of all, think about the time and money it saves you to be able to create an email group, attach a PDF, and hit send, as opposed to photocopying, stuffing envelopes, paying for postage, especially in larger communities. And quite frankly, for most owners, they would prefer email because they will get it anywhere in the world they are, as long as there's an internet connection. And I would ask those of you listening to consider how often you have gone to an annual meeting where you sent out election ballots and there are people in other parts of the world who did not even get them in time to send them back and vote. So using email is a wonderful convenience and a cost saving for the association, but it also is a significant benefit to the owners to facilitate participation. So you have verified notice. And some of you will have an order of business in your bylaws that you're supposed to follow. Sometimes it says to the extent practicable. But the first thing is to verify notice. The second thing is to verify that you have a quorum of the board present. Then you go into your agenda. And the way to address the agenda is, for each agenda item, someone should be prepared to present it, whether it's the president or the secretary or the treasurer or even a committee that's going to make a presentation. There should be a presentation of the issue. If you're, for example, considering a new landscaping contractor, whoever undertook to solicit bids and evaluate other landscape companies, or the committee, if you have a landscape committee or a building and grounds committee, should present what they've done and present their recommendation for who to hire. At that point, the board members make comments and ask questions. At that point, once the board is done, you turn it over to the members present and say, do any of the members present have any comments or questions? And once that is done, you take your vote. Now, in some communities, a motion is made before you open it up for comments from the board or the members. A motion is made and a second is taken. I do not believe you are required to do that. Robert's rules may require it, but I think it's premature, because based upon the comments, questions, other input you get from the members and the board members, you may have to modify the motion anyway. Either way, you must take comments from the board and, more importantly, from the members before you vote on the item. To do otherwise, to me, frustrates the purpose of the statute that allows the owners to attend and participate in the discussion on all agenda items. If the members can't participate until after the board has voted on an agenda item, to me, that is not compliance with the statute. It's just not what it means. It would make no sense. I know there are boards that don't allow member comments until everything is done. To me, that is not what the statute contemplates. So, once the matter is, a motion is made, seconded, the discussion is completed, you vote, you move on. Now, for minutes purposes, remember, you are required to record how each board member voted. And then you do the same thing for the next agenda item. Yes.
So what's your recommendation when a board member goes off topic?
You mean off the agenda?
Correct.
Well, I was going to talk about this later, but let's talk about it now, because it's not just board members. Some of your board meetings are disrupted by people who just want to talk about what they want to talk about. Some of them will raise their voice. Some of them will yell over the board. I've been doing this for 42 years, and the atmosphere in the communities is reflective of the atmosphere in the country, which is highly contentious. People have become much more argumentative, and the atmosphere in a lot of communities has become very contentious, sometimes even toxic. One way to combat this is to be businesslike in the way you approach your board meetings. Come prepared, have a notice properly posted, go through the agenda in a businesslike way. If you don't, your dissidents will smell blood in the water. So you need to be organized and businesslike, and I cannot overstate the importance of the board members coming to board meetings prepared to discuss the agenda items. If you're a board member and you're not willing to spend the time to prepare to discuss agenda items in an intelligent and businesslike way, you probably don't belong on the board. As far as board members going off topic or members shouting over the board because they want to complain about who knows what, I would never encourage anybody on the board to engage in a physical confrontation, but I do have boards that have begun to hire off-duty police officers, uniformed off-duty police officers, to attend their board meetings. That tends to have a deterrent effect on people from misbehaving. I would also consider that you videotape your board meetings, because if you have members, whether on the board or not, who are disruptive and attempt to interrupt the meeting and prevent the board from conducting its business, I would hate to think it would get to this point, but at some point you may have to show that videotape to a judge and say, Judge, we want you to issue an injunction to prevent this owner from attending board meetings in person. Make them attend by Zoom where they can be muted. Use technology to facilitate participation, but also to control participation to the extent you need to. You obviously want to encourage unit owner input. You want to encourage unit owner attendance, but you do not want to allow owner disruption, whether it's from a board member or somebody in the audience. Now, based upon a recent amendment to the Condo Act, there must be meetings at least 4 times a year in which the owners have the right to ask questions about things that are not on the agenda. You can ask about fiscal management, you can ask about construction projects, or any other item of interest. The owners have the right to ask questions. Now, it's worth noting that the statute doesn't say that the board has to answer if it's not prepared to give a correct answer. I would never counsel any of my clients to try to answer questions that the board is not prepared to answer correctly. And to the extent questions are asked, the board is not required, nor should the board act on those things that are not on the agenda. Before this statute came about, I always took the position, if you wanted to have a section of your board meeting called new business, I always took the position that new business is not to take up items that were not on the agenda, but instead to take up items that are suggestions for inclusion on a future agenda. Mm. And that's the way I would approach this right of the owners to ask questions at these meetings. So, let me make sure I covered everything I wanted to cover. I've sort of flown through it.
I have another question. So you mentioned emails as a helpful way of communicating outside of just the mailing or the posting in a conspicuous area. How about text messaging?
These are all permissible as long as they are not done in lieu of an open, complete discussion at the board meeting. For example, you would not want to be at a board meeting and say, we're discussing hiring a new landscaping company. We've already circulated emails on this. Everybody has expressed their opinion. Let's just vote. That's not the way it should go. I'll take a few more questions at this point, just so we can sort of clear the decks.
Sure. So let's see. This question is, how do you get around being classified and filtered as spam when you send out notices to owners who have consented to receive notices via email? For example, let's say you have 40 owners who have consented to receive it via email. I don't know.
It is not the association's responsibility to deal with the spam filters on each owner's email chain. That's up to the owner to make sure that the emails from the association are not marked as spam. And at the beginning, the owner should check their spam folder, and you can label the emails from the association as not spam. But that's not the association's burden, because the association can't control what each owner labels as spam in his or her inbox. What else you got, Michael?
Another question is, can you adjourn the meeting and then reopen it 10 minutes later when everyone's settled down?
Rather than adjourn the meeting, you could say, let's take a recess. There's an important difference between those two terms. Recess means we're going to take a break. Adjourn means the meeting's over. So you certainly can recess meetings, but the fact is, some of the people who come in to be disruptive, they're not going to settle down until you do what they want. Let me talk for a second about that. I have a lot of communities adopting what I would call a civility code that requires owners to conduct themselves with a level of decorum and courtesy at the property, not just at meetings, but generally at the property, in the way they interact with staff, in the way they interact with other owners, in the way they interact with board members, in the way they interact with contractors on the property. A civility code is helpful. And I realize that civility is a subjective concept, but if you have real problems with people being disruptive and frankly just being obnoxious, it's something you have to consider. I also have a lot of communities adopting a board and committee member code of conduct so that they have to act as part of a group as opposed to unilaterally, addressing everything from conflicts to respecting the confidentiality of unit owner information, to not going out and undermining board decisions once a decision is made. It is an extensive policy. And I guess last but not least, for those of you who haven't addressed this in your governing documents, the law has for over 20 years allowed the association to levy fines and impose suspensions of use rights with some limitations. The beauty of this is you don't have to pay lawyers. You don't have to file lawsuits. You can address violations in-house, which to me is a useful remedy. And the adoption of an amendment that authorizes fines and suspensions, unless your documents automatically incorporate future amendments to the statute, the adoption of these amendments and the creation of a grievance committee to impose these fines and suspensions in and of itself has a deterrent effect on misconduct. But as I said, one of the benefits, for example, if someone is obnoxious at a board meeting, going to your lawyer and saying, file a lawsuit, I want him thrown out, thousands of dollars later, you're going to feel like, why didn't we just fine this guy $100 every time he's obnoxious? Maybe he'll think about it next time. Maybe he's got unlimited funds. But talk to your counsel about the most practical way to enforce provisions. There will be violations that will warrant formal legal action. Serious violations that affect the safety of the other members and residents or which affect the integrity of the building. However, certain behavioral violations may be better addressed by invoking fining and suspension authority. What other questions?
Can you allow members to ask questions on agenda items at the beginning of the meeting for all agenda items?
I wouldn't, because it's out of context. It makes the board meeting and the discussion at the board meeting disjointed. I think it is best to cover each agenda item one at a time, have it presented in a thorough way, whether it's a committee or a board member or an outside expert. I've been at board meetings where the board wanted to propose amendments to the members for consideration and solicit input before they were mailed out with a proxy, and they asked me to discuss and explain the amendments. But after I do that, I invite questions from the board, and then I invite questions from the members, and then the board decides based upon those questions, what edits to the amendments that I've already drafted do you want to make? So there's a logic to going in an appropriate sequence so each agenda topic is addressed distinctly, but completely.
Another question here, is that meeting recording requirement to be available on the website only for condos, or does it apply to HOAs as well?
I don't recall whether it applies to HOAs, but I would do it. I think it does, but I would post it anyway. Yeah, let's talk about posting. It's a little bit off topic, but let me say this. If you have a website and you have the right to tell owners who are requesting access to official records that they can go to the website because it's posted there, think about how much more convenient that is for your management and your staff. So I would always err on the side of transparency and openness. If you've recorded a board meeting, I would post it regardless of which type of community you are. You don't need to leave it up there forever, but you should post it.
So that leads to the next question. After 1 year of recording posted on the website, do you need to keep the recording as an official record?
If the minutes have been transcribed and approved, I believe you can discard the recording. However, depending upon what was done or what was said at the meeting, it may be appropriate to keep it. If you've received a spoliation of evidence letter from somebody who wants to sue because somebody said something slanderous, you're going to want to keep the recording as evidence. You're probably required to keep the recording as evidence. But I also understand the fact that video and audio recordings are space eaters on a computer and on a website. And I believe that is why the statute only requires these things to be kept on the website for 1 year.
Last question. Is it appropriate or necessary for the president to issue an overview of what will be covered at the board meeting, but without specific details before the agenda is published?
Well, I assume when you say provide an overview, you probably mean to the board members. I'm going to assume that's the question. And I've seen way too many boards that have become fractured where you have two different segments of the board that are working at cross purposes. I'm sure you're seeing some of that too, Michael, in the communities you manage.
Mhm.
That's a bad look. The board members are fiduciaries. They're expected to take the proverbial high road. When you're planning the agenda for a board meeting, you should always notify the board members that you're doing so, and you should solicit their input. Doesn't mean you have to include everything, but you have to at least solicit input. Is it required? No. But remember this, if you're a board of 5 and your bylaws say that 3 board members can call a special board meeting, and 3 board members say we want this on the agenda, if you don't put it on the agenda, they can compel a special board meeting to discuss it anyway. So why not just do it?
Another question is, what is the procedure for establishing a rule? And once established, do you only need to mail the new rule to the homeowners?
Very good.
They don't need to be filed, correct?
Very good. Well, let me say this as a practical matter. How are you going to expect owners to follow a rule that hasn't been published to them? So if you're going to adopt a rule as a board, first, you must make sure that you have rulemaking authority. Second, you must make sure that your rulemaking authority extends to the entire property. Sometimes rulemaking authority is limited to the common areas or common elements. So that's step 1, is do we have the authority to make this rule? And step number 2 is maybe we should talk to our council to make sure the rule says what we mean for it to say. Because I've seen my share of home-cooked rules over the years, and they almost never say what you really intend. If you're going to adopt a rule that affects the use of the units, you need 14 days notice posted and mailed if you're a condo or a co-op. Once the rule is adopted, bear in mind the rule that is mailed out doesn't necessarily have to be what the board adopts. It's a proposed rule. It's called a proposed rule for a reason. But you should, once it's adopted, update your rule book and send notice out to every owner of this new rule. For example, if you adopt a civility code, you should publish it to the community and make it part of your rule book. It's hardly fair to expect owners to comply with rules that have not even been brought to their attention. Now, I want to add one other thing. For board meetings, do not use your authority to make rules as a backdoor. There are certain changes you may want to implement, certain restrictions you may want to implement that actually require a membership meeting to amend the governing documents. So rulemaking authority is absolutely something you should discuss with your association council to make sure you have it, to make sure it extends to the rule that you want to adopt, to make sure the rule doesn't conflict with anything expressly provided for or even inferable from the declaration, to make sure the rule that you're proposing says what you want it to say, to make sure the rule doesn't violate the law. Adopting a rule is not as simple as saying you can't do this anymore. It requires a little bit more analysis on the part of the board.
Can board members limit how long members speak?
You can adopt rules regarding member participation and member recording of meetings. For example, you can adopt a rule that requires members to notify you in advance if they want to speak at a meeting. I don't really favor those rules because most members can't do that, and to bar them from speaking because they haven't notified you in advance seems a bit unfair. But if you are a very large community with several hundred units, that rule may be more useful in that setting. In a 40-unit condominium where maybe a dozen show up at meetings, I think that rule is a little bit draconian in terms of allowing the members a chance to speak. Most rules will say that you can speak for 3 minutes on each and one time on each agenda item. which is not unreasonable, but you also need to make exceptions for people who, for example, for any expert that you bring in to address a topic should have the right to speak on it as long as necessary. You should allow the chairman to extend the 3-minute limitation where he or she determines it is appropriate to do so. And as far as unit owners who want to videotape meetings, there should be guidelines that prevent them from videotaping in a way that involves them moving around the room or having light or sound that is disruptive to the meeting or putting in wires or cables that create a tripping hazard. So you can adopt rules in that regard. And with regard to participation, particularly if you're having some difficulty with some owners, it's worth doing in conjunction with a civility rule. Because somebody can be obnoxious in less than 3 minutes.
Gotcha.
So some people can be obnoxious in less than 3 seconds.
Indeed. I have a few more questions, but before I ask those to you, I wanted to drop this course evaluation. If you're in this webinar to get CEU credit, please complete the evaluation that I just dropped on the screen to make sure that you get that accreditation. All right, so a few more questions. Ken, thank you so much for your time here. How important is the role, in your opinion, your experience, for the chairperson in the board meeting to set the tone for the meeting, set expectations for how the meeting's going to be ran?
I think it is of critical importance that not just the chairperson, but the entire board conduct themselves like fiduciaries, like business people at a business meeting. I think it is of critical importance that the whole board set the tone. As I said at the outset, and as you correctly pointed out, Michael, it is critical that the board set a tone that says, we're all prepared. We're going to conduct ourselves in a business-like manner. I have some communities where there are people who just stay on the board because nobody else wants to run. And I have one where a guy is on the board and said, I'm just here to be disruptive. That's not what you want from your board. That's never what you want from your board. So the answer to your question is a hard yes. The board chairman should set the tone for the meeting, but the entire board has to be compliant with that tone and support it.
So can you share maybe some practical ways to enforce professionalism without escalating conflict?
Well, be prepared. Have a board and committee code of conduct as to how board members have to conduct themselves at board meetings. Have a civility rule as to how owners have to conduct themselves at board meetings. The more organized and businesslike you are, the less likely it will be that people will be disruptive and interrupt you. Now, some people just can't help themselves. I get it. But the more prepared and businesslike you are with your meetings, the better you are. Now, as far as the chairperson for the board meeting, some communities have, most communities, I should say, have the president serve as the chairperson. But you also have to decide whether the president is, in fact, the best person to chair the meeting. You may have someone who has a little bit more business experience in running meetings to run the board meeting. I've been at meetings, both board meetings and membership meetings, where the board has asked me to run the meeting. I prefer for the board to elect a chairperson to run the meeting, but I will do it if necessary. But this is a long-winded answer to simply say yes to your question. It is imperative that the board set the correct tone. And gotcha. and the tools of the trade are be businesslike. And if you have people who simply cannot conduct themselves, hire an off-duty police officer. Never, ever, ever have individual board members engage in physical confrontation with members. Never. We still have the course evaluation up on the screen, so I don't know if that's intentional.
They could drop it as necessary, but
okay. Let me sort of wrap things up as you gather whatever additional questions are coming in by summarizing a pre-meeting checklist. Number one, make sure notice was properly given. And that the importance of that cannot be overstated. This is dictated by statute, dictated by the bylaws. Consult your counsel. Number two, make sure a chairman is going to be appointed who's going to be there and is the right person to chair the meeting. Make sure that someone is there to take minutes. Usually that's the secretary or a representative of the management company. Make sure the meeting room is set up. As I alluded to earlier, I do not believe that you can have board meetings by Zoom only. There has to be a meeting site where people can attend in person. For some reason, the legislature decided last year that for the annual meeting where there's going to be an election, you need to have at least a quorum of the board there in person. I do not know why the legislature mandated that, because a membership meeting is not a board meeting. So why a quorum of the board would have to be there is beyond me. I don't know what the legislature was thinking, but that's now part of the Condominium Act. Make sure the meeting room is set up with chairs and is ADA or FHA accessible. If you have owners who are recording and have notified you in advance, if your rule requires it, have a list handy so that you will know who will be recording the meeting. Make sure that all materials that need to be considered by the board are distributed to the board members in advance. You cannot expect board members to come to the meeting prepared if you have not distributed the necessary materials. That means if you're considering contracts, circulate the proposed contracts to the board. If you have committees that are making presentations and recommendations, have the committee generate a report that can be shared with the board members that they can read and study and come prepared to comment on at the meeting. If you're going to consider adopting rules, circulate them, and maybe even circulate an explanation as to why they're being considered. If you're going to be approving a major construction contract, make sure that all board members have the engineer's recommendations, have the engineer's findings and proposed specifications. Again, you cannot expect board members to be prepared if you haven't provided them the data and the information. If you have, as I've said a few times here, disruptive owners, adopt a civility code. Adopt a code of conduct for board members as well. And in the worst case scenario, have an off-duty police officer there to enforce order and prevent things from escalating. I want to speak for the last topic I want to talk about is who has the right to attend board meetings. All owners have the right to attend. So what happens when a tenant wants to come to a board meeting? Does a tenant have the right to attend? The answer is actually no. But you need to be careful about addressing this kind of attendance. I have owners who occasionally want to bring their lawyers to the meetings. I typically say you have no right to come. But if the board has allowed other non-owners to attend meetings, it creates a selective enforcement argument. And when I say other non-owners, that could be units where the husband and wife live there, but only one of them is on the title, but both spouses have been allowed to attend meetings, or where you have an unmarried couple where both have been allowed to attend meetings, but only one is on the title. So you need to make sure that you're being consistent in the way you enforce who has the right to attend. And with that, I think I have exhausted the materials I had planned to discuss.
Great. Thank you, Ken. Before we wrap up, I'd love to give you an opportunity to share if anyone here has follow-up questions or needs guidance. What's the best way for them to connect with you or your team?
Well, obviously, legal questions should be directed to the association's attorney. I've been at the law firm for 40 years next month. And you can reach me at kdirektor, DIREKTOR, at beckerlawyers.com. But I need to be clear, this isn't an invitation for a barrage of legal questions, because I can't give legal advice to people who are not my clients. Even though I think I've probably done so for the past hour.
Thank you for that. Ken, again, thank you for sharing your expertise today. this was incredibly valuable. And I know there's a lot here that the attendees can take away and apply right away.
No, and I appreciate that. And my apologies to the listeners, because I went through a lot of information, frankly, rather quickly, but I wanted to make everyone aware of all the issues you have to consider without necessarily drilling down too much on any particular issue and running out of time to talk about the rest. So, Michael, I want to thank you for inviting me to participate, and I hope it's been informative to everybody who's been listening.
Absolutely. All right, everyone. We'll wrap it up there. Thank you.